Yeah, I think we can start the session. So hello everyone, welcome to our session on contract management phases, a practical workshop which will be conducted by Camelia. So to introduce her, she has worked as contracts and project directors in large-scale EPC and EPCM projects for more than 12 years, managing commercial transaction claims, mediation procedures, as well as the project execution, operation, and legal processes. So, in short, if I have to tell, uh, with an experience of more than a decade, she has worked in various levels of contract management. That is why we have come up with this contract management phases, because she in person has experience in all of them, from negotiation to execution and then compliances and all other things. And also she has worked as contract and project director during this time, managing relationships with clients contract worldwide in Canada, Niger, and France. Currently she is serving as project execution director for SPX Flow France, a food and beverage product line with a portfolio of worth more than 1 billion euros. And we are extremely privileged to have you here, Camilla, to speak to our students. And I'm sure all of them would be taking a great uh, knowledge from here. And also, if anyone has any questions, you can keep it at the end of the session, or you can post it in the chat box so that once she's done, she can answer those queries. It's over to you.
Hi everyone, good morning, good afternoon everyone. So for this first session of contract management phases, mainly in a practical workshop, so we'll be taking many practical aspects of contract management phases. I have chosen for you the following summary. So we'll start with an introduction, then walk you through the contract management phases, who is involved when we talk about contract management phases, and what is the role of contract manager, and what are the other functions that is or she interacted with. Then walk you through some key points and basic notions. The parties' obligations, when we talk about the parties' obligations, what we mean, in general. Give you some examples from some practical cases, then conclude, and after that, answer your questions. So a little bit about me, as Ms. Kritika have told you. So here's just some more details about me. My name is Camelia Bonnoir. I'm 37 years old. I'm a French and Canadian and Moroccan citizen. My education is, I have a master's in project management in industrial engineering. I choose the option of project management for my master's from Polytechnic School of Montreal. So my current job is at SPX. So I'm working mainly on process technology. And before, I had the chance to work in a electrical power plant, so the contracts covering the electrical power plants and their power plants and their construction, their design, conception. And before, at the beginning of my career, I was managing the civil works, so the large EPCs in Niger and in Canada. I can tell that I have developed some strength during my career, so regarding negotiation, critical thinking, and problem resolve, that I'm still developing while seeing my many cases and many challenging, I can tell, situations. And also I can describe myself as stress-free. I'm always learning. It's still a long journey to learn and having some areas to improve. So that our delegation, I want to know how to delegate more, and also interests to develop my technical knowledge in the process, because it's a very large domain and challenging. When we talk about project, it's in general for me, if I have to resume it in three main phases or main critical, I can tell them success points is time, quality, and cost. they are linked together. If we have a slippage in time, it's definitely affect cost. If we have an issue, a quality issue, definitely affect both time and cost. And of course, if we don't have the budget of the project, nothing can happen because the project cannot happen. So either we will postpone the project or stop it, or sometimes even try to reduce the quality that gonna affect mainly the project. So as contract managers, what are we doing to make this triangle a success? When we talk about contract management in general, so it's a process of managing the contract from its creation until the end. So we are doing in the execution, we are analyzing what are the contract clauses, the phases, the risks, and the challenges, opportunities to maximize the operational and the financial performance of it. While, of course, a key word here is reducing financial risk because we want to execute the project within its margin, within its cost. If we were like 200 years before, we will not be hearing about what contract management, because clients were performing projects by just a shake hand. But now, with the economy becoming more challenging, with the cost becoming more challenging, so it's became, the contract management became, a very, very demanding function, and to reduce the cost and to improve the company's performance. So as a contract manager, we are responsible for the streamlining of all, from the creation, negotiation, execution, completion, and even the storage of the contract documents, either now or after the closure. There are some tools now, it starts to be, I can tell, the fashion, that there are some tools developed mainly for the contract management, but I can tell it's still ongoing, and the companies, they are still implementing them. Here, just some, I can tell some signs or some abbreviations that we will be using during this presentation. So when I say IMC, it means installation and commissioning. PROD is production. TNC is, that everyone know, term and conditions. APG, advanced payment warranty. PM or CM is contract or project manager. LD is liquidated damages. KPIs, key performance indicators, extension of time EOT, CVO, change variation order, BG, bank warranties, LC, letter of credit, and TOC, taken over certificate. So a contract management phases, it's a very, I can tell, a complex, broad, but to make it very, very, simple and high level, I can tell that we have a first category or a part of the tasks that are tendering phase. So there is a phase of tendering, contract review, commercial negotiations, and transfer. So this we can, consider them as a category one that will be given a name later on. And then we have the PM or the CM, depends on the organization, because sometimes it can be one person that constitute the team. So, they are constituting the team that will be involved with the project, who will define after that during this presentation, a definition of this team, and they are the one who is doing what. Then design phase, production and delivery, as I said, installation and commissioning, warranty period, and after that we call it aftermarket or client service, depend on the nomination. So if this is, I can tell, the very simple diagram that describe the contract management phases. To make it, as I said, a category before, so we have tendering phase, where this first category is included, which is contract review, tendering, commercial negotiation, and transfer. And for the execution phase, we have the rest of the tasks. So during each phase, we have many people involved. The contract manager is not doing the job by its own, and they can't. And either each person within the company cannot execute the project by its own. It's a teamwork, either one team succeed or one team fail. So who are involved? We have engineering department. We'll see after that what they are going to be doing. Lawyers and legal team. Sometimes a contract manager can be a lawyer as it can be engineer. So this is will be maybe developed in other sessions. Finance team, cost control, project management, sales management, planners, supply chain, logistics, and site team. So let's have a quick definition of who is doing what, when, and how. Engineering. So engineering, they are involved as well during the whole, I can tell, phase of a contract or project life cycle. So they are in charge of developing a technical specification. As a contract manager, we will be sure that the technical specifications are well defined comparing to the client's request. If there is any deviations, they are there, they are clear. So once everything is settled in the proposal phase and the preliminary drawings are set, so the engineering will be doing the detailed study. So with the contract manager, it's a day-to-day follow-up. If we had all the approvals that we need on time from the customer, if everything is clear to all parties, if the progress is I mean, if the works are progressing as per the planning. And then when all the engineering phase, I can tell it's concluded, then we have what we call, I mean, a bill of material that is gonna be given to other functions to see to proceed and progress with the project that we're gonna see later on how it all will be. Sales manager. So once the proposal team, which mainly the engineering, have defined the scope and I mean do the price related to it. So we need to be sure that the sales manager have consolidated all the price if there are other functions, if there are other costs to be included. So the main person here is the sales manager, and we are as contract management involved. So we are following step by step what's going on. They are I can say they are the channel of communication with the customer together with the contract manager when it comes to some legal and contractual phases. We are here to support, the whole exercise of negotiation. And then sometimes the sales manager, it doesn't, it's, I can tell, rule doesn't end after the signature of the contract. They still will be here, and maybe as a contract manager will be interacting with them when it comes to a big claim or the big discrepancy during the contract. So they will be here supporting us to maintain the good relations with the customers. So it will be give and take from each party. So it will be playing roles to have everyone online and to keep the relations in a good shape. Lawyers. So as I said, a contract manager can be a lawyer, it can be engineer, but a legal team is here. It depends on the organization. Sometimes, the contract management is within the legal team. Sometimes it's within the operational department. Depends on the company's organizations. So as legal or lawyer, we need to confirm the governing law and the regulation. We cannot sign a contract without a law governing it. Even if we think that a contract covers all the terms and conditions, it will be always things silent, and the law gonna complete them if things are silent or if the law sometimes prevail on what we are signing. Legal clauses such IP, such confidentiality, such exclusion sometimes of some articles of the law, the main person to validate is the lawyer. So as a contract manager, we need always to link with legal to be sure that we are online with those regulations. Even during the contract execution, the regulations will always prevail. So we'll be sure that we are respecting them, we know them, and to be online with the other parties involved in the project. Planners, we cannot sign a contract without a planning. It's a must. Sometimes a planning can be a date of completion, can be a date of delivery. So this date, or in a big project, a detailed planning is must to be here. So it needs to be here, and it needs to be online with a contract procurement. So we need to be sure that all the milestones mentioned in the contract are mentioned in the planning. Sometimes even the payment terms, they need to be mentioned there to be sure that we are online with what we need to give. And sometimes we have some critical milestones that are mentioned in the contract. They need to be mentioned there. Some LDs can be linked to them, but it needs to be clear. And then during the execution, depends on the project. In a big project, we can go in some, I can tell, detailed levels in the planning. But we have, if it's in a must mentioned in the contract, then we need to be sure that everyone is aware about this obligation and that the planning is clear, is always keeping updated if the contracts change, if the dates changed, if the specifications changed. So we need to be link up always with the planners and be sure that everything is on track. And if not, update the plan. Finance team, we need to interact with the finance team when it comes to payment terms to be sure that our cash flow is positive, that we are accepting payment terms, that they will keep our cash flow in a good health. We need as well, if we have some contracts that we need to issue the bank warranties or need to be paid under letter of credit. So to be sure that our banks are online with those templates used, that we have some templates used in the contract to not waste time and start in negotiation. Once the contract is executed, so we will be losing time and also affecting the contract progress or the project progress and our cash flow when we'll be delaying the payments while waiting for the negotiation. So as a contract manager, we need to have all this vision for all those functions and those points to be set. The cost control, this function is mainly start to be a part of the project, I can tell, during the execution. So this is the team that they are in day-to-day basis tracking the progress of the project in terms of milestones, in terms of closure of each, I can tell, stage gate, preparing the project reviews. So we need to be sure that they have the right information, that the project is updated on our system based on what we are negotiating during the project life cycle. If there is any change, so they have the right documents to conclude this change on the system. Supply chain, this function, we interact with them during the early stage in the contract and also during the procurement phase in the execution time. So we cannot conclude a planning without having the time from our suppliers. So as a contract management, we need to be sure that the planners have linked with the supply chain to come up with the planning and come up with the reasonable deadlines that we can take an engagement to, that we need to fulfill, so to avoid any risk during the execution. There are also sometimes that some vendors they will challenge with their T&Cs with other matters, so we need to support this function to be sure that they have all the support that they need and that they will not affect the progress of the project, and also if there is any delay, it happens I cannot tell it's an exception. It happens, or 80% to be optimistic. In the contracts that we have some vendors that they are causing us some delay. So we need to work with the supply chain to have a recovery plan, to explain to the customer, to keep the relations. So this is one of the function that we need to support, and we need always to keep involved and in track while managing the contract. Site manager, if we have a project that includes site works, so we need to, as a contract managers, to keep following the progress on site, that it's with the planning of the contract and people executing the work on site, that they are online, they are on the same page, that they know what are our obligations, what are our rights, that we have reports, if any, because in some contracts we are obliged to give reports, so that they are aware about this obligation. They give us the information. Logistics. This is when it comes to delivery. So prepare the shipment document as per the Incoterm to be sure that all the parties are aware about the Incoterm, are aware about our rights and obligations under this Incoterm, that they are on track with the planning, that they are hiring the forwarder on time, that if there is any delay from the forwarder, from any party, that they are reporting it to us to manage the shipment. If there is any, sometimes it happens that there is damage of the equipment, so they manage with the insurance, with the client, if we need to have any recovery plan. So we work with those people to involve our insurer, if it's, of course, it's within our part, or if it's the client who takes care of the logistics, then give them the right document. If there is a delay caused by them, so it needs to be reported, and to keep everyone on track. And then, of course, it will affect other functions, so to be sure that it reflected on the project progress. Project management, sometimes it's the same person as a contract manager. So the contract manager will do, in addition to all these activities, the same activities as the project manager, or sometimes it's totally two separated functions. So and the contract manager is here to support the PM community. So when we have a project manager on a project, so he's mainly in the execution phase, is the man of the show. We can tell that is the man or the woman, sorry, of the show. They are the ones who coordinate the project activities, the main communication channel with the client. They are tracking the project progress and initiated actions accordingly, ensure that all the parties are aware of their right and obligation. So here we are supporting in this part to be sure that they know their rights and obligation, that it's clear. I can tell you that in our contract, it's clear. Sometimes during the execution, we discover some discrepancies. We can discover some unclear things. So to be sure that everyone in the same page, and of course work with them any amendment of the contract if it's needed. So the role of the contract manager, we can really resume it within the two phases like this. So during the tender stage phase, how we support all these functions that we say before. So we draft and review the T&Cs of the contract. We assist the team with the client's negotiation and the tender phase. So I can tell this is the conclusion that what we have seen before. So to be sure that all the team members use the last work template, this is very, very important, because an organization takes a lot of time, a lot of effort, a lot of money to set the procedures templates, but sometimes people, they are comfortable with other versions, so they keep using these versions. But as a contract manager, we need to be sure that all the procedures, all the updates are applicable within the organization. To use the last version of the technical specification, this is very important because when we start negotiation, we start a version of the specification, and then after that, it can evaluate, it can progress, we can have some deviations. So to be sure that once we, settle in the contract documents, the last versions are there and there is no discrepancy, because if you use something very old, it will be binding and then it will have issues during the execution. If we refer to an annexure within the contract, it will be listed, it will be it will be attached. So sometimes we can refer an example to a bank guarantee, but when we go to the annexure, it's not there. So it means we need to start negotiations of this bank guarantee since the beginning, and we will be losing time. If they will have any, testing methods, any capacity, any KPIs, any deliverable, so we need to be sure that they are well defined. How we can achieve them? When? If we don't define, it will be during the execution, it will be another restoring of negotiation that it can cost us time, and time costs money. If there is any LDs in some contracts, as a supplier or maybe even as a client, we are liable to LDs. So to be sure that those LDs are within our limits as an organization. If there is, if the other party needs some LDs that they are not within our limits, so we need to be sure that if they are not approved within our organization and they are included, it will cause us trouble, because sometimes we will be solicited to go and to renegotiate a contract, and it will be a big conflict. So be sure that everything is aligned with the organization rule. As we said before, payment terms within the cash flow and the applicable law are approved by the lawyers. So we need to be sure that there is, sometimes we say it's as per the client or the supplier or the party's place, and within the organization, we are not allowed to use such law. So to be sure that if we use a law, that it's validated by the legal team. When it comes to the execution, so we'll define and clarify the rights and obligation of the party. This is, even if we clarified it in the beginning, this is a continuous exercise, because within the execution, both parties can have different interpretations, can have some discrepancies or some misunderstanding of where is included, where is not. So we will be always here to support this task. We need to be sure that the contract documents are transferred to the execution team. If there are any documents missing, so we need to be sure that we will have them at the beginning of the contract, that the contract is aligned with planning. Sometimes we sign, in a date, and after that the contract they come in a date. So where is what is date of the contract in this time? So to avoid this misunderstanding, we need to be sure, we need to update the planning if it's need to update it after the conclusion of the contract. If there is any bank guarantees, we need to be sure that they are issued on time. If there is any documentation related to each payment, so we need to be sure that they are issued, because if they are not issued, it means that we didn't reach this payment milestone, and then, we will not be paid on time. We need to track the execution progress with the team, to be sure if we are within the planning, if we need to set a recovery plan, if we need to support an extension of time, and also if we need to secure, in this case, a CVO, if there is any change in the contract, if we are late. To always happen. A party can always be late. It's not an exception. It's not a failure. It's something that we are, as while doing project, while doing contract management, it happens. So we need to be sure that we have a recovery plan for it to mitigate those delays. Key points and some basic notions over here. We are repeating it, but it's super, super important. Contractual rights and obligation need to be drafted clear. both parties have the same understanding. In case of confusion, we need to sit around the table and sign an amendment. Clear communication should be transparent, respectful matter. Sometimes it can be a frustration can happen, but we need to control ourselves to be respectful, to not offend anyone. When we are communicating to customers, sometimes even explaining either to the customer or supplier, to a party, avoid that we promise something that we cannot fulfill. Even if to make the party happy, we shall not promise something that we cannot fulfill. We shall stay credible, proposing a solution, but it shall not be understood as a promise that will be for free. And always have an agenda. So when we go to a meeting, if we don't have an agenda, everyone gonna be talking about problems, suggestions, issues, and then we're gonna, have like hours and hours and hours of meeting without any clear communication, just increasing frustration. Continuous notification. Always keep the project stakeholders informed by periodic meeting, progress reports, a phone call sometime, and confirm it by email, but always keep the person or the stakeholders informed. Because if there is like a big silence and then something happened, it will be difficult to keep the relation. It will be difficult to negotiate. It will be difficult to stay, I can talk with them. As we say in French language, les paroles s'envolent, les écrits restent. So always have a written record. This is very, very important. As I said, clear communication, continuous follow-up. Follow the negotiations with the customer when we are, or the party when we are negotiating. If we disappear after 3 months and then come to another subject, we will redo all the job that we have been doing since the beginning. Sometimes we need to sign reminders, so that shows that we are having control of the situation. We are interested. Sometimes we have in front of us a party that we are not the only person. If we are a supplier, we are not the only one offering service. We are not the only one having this technology. But by a follow-up, by a professionalism, we can be the preferred one. If it comes to the execution, once again, manage the period related to each phase as per the contract for planning during the execution. Follow up that even everything on track to show that we are on control, to show that if something happened, we are updated, we know, we follow. Keeping record, this is a very, very, very important. I can tell point is we need always to keep records by letters, emails, timesheets regarding any event. An example, during the site works, we have some additional works that weren't included in the contract, and we want to claim them. If we don't have any timesheet, if we don't have any email, cannot tell them, yesterday we did this, this, and this, and it wasn't included. Show me who is doing it, how many hours, how did you do it, who approved it, did the customer agree on that? If we don't have records, we cannot have this extra job work. A record can be, as I said, letter, email, timesheet. It can be a progress report. It can be a minute of meeting. It can be a photograph dated, so it shows the progress. This is the day 1, we were at this. Day 7, we were at this stage, so it shows the progress. Of course, between brackets, dated, and when we are allowed to take pictures on sites, because in some sites when we have like super confidential information and we are not allowed to take photographs, so we need to avoid. But of course, we are always allowed to issue timesheets, to get them signed, to issue emails, to issue letters, minute of meetings, and reports. As one of the key points, detailed planning. Show the right commencement date or the coming into force in the contract. If it's signed, sometimes during the negotiations, we lose some time. So once it's signed, update the planning, clarify when is the commencement date, is the down payment, is it the signature, is it the reception of, I don't know, of like a specific document from the customer or from the other party. So it needs to be crystal clear on the planning and should be this date 0. And then from this date, we can follow the other dates. If we have any penalized milestone, it needs to be crystal clear in the planning. So for example, we are talking about delivery as penalized milestone, but when we go to the planning, we don't see when the delivery happening. We just see the date of completion or the date of installation or the date of engineering. It will be difficult to define this date, and it will be a very frustrating debate with the customer. As I said before, if you give a word, fulfill it to stay credible in front of the customer. How you stay credible with the record, because you say, okay, this is what we had said, and this is what we had promised, and this is what we had in our contract. Detailed planning, this is the date, and this is what we are doing. Management of the priorities, this is very important. In general, we don't manage one project like in many cases. We can manage one project when it's super big, but in practical life also we'll have many projects. So define the priority. Each task is priority. You cannot ignore a project and don't do anything to it and prioritize another project. But you need to see, okay, I will do this task first. It means I will not ignore the rest. I will always keep in mind that I need to do this. And this is just, first priority doesn't mean the other, it has no value. And we need to set our priorities and to follow them and to be sure that while setting these priorities, we are not penalizing ourselves. Risk and opportunities anticipation. While doing the project or the contract management in the contract, we can spot the risks as we can spot the opportunities. So we need to keep them on track. We need to keep them alive. A risk, it means we need always to have a mitigation plan in front of it. And an opportunity, we need to have always a proposal in front of it and follow up with the customer and to have a success opportunity and to not, of course, turn it into risk. Keep in mind is nobody is perfect. This is, for me, is super important. It's not pessimistic statement, but as a customer, we can miss things. As a supplier, we can miss things. It doesn't mean if we miss a thing, that's it. We are the guilty party. We are the responsible of or the problem and issues of the world. No. While negotiating, we need to analyze the situation and see what the other parties are missing. So we cannot admit the responsibility directly. It should be at least a shared part. Okay, you did this, we did this. Now we need to find a solution. And while discussing this, we need to believe in our position. Because if you don't believe in your position, nobody's going to believe you. If we just go in front of the customer or in front of the other party and we not be confident about what we are saying, be shy what we are saying, we cannot sell it to the other party. We cannot explain it with confidence. So the other party gonna spot this weakness. So to be sure that we know what we are talking about, we are confident and we believe in it. Parties' obligation. When we talk about client's obligation, it doesn't mean the client just needs to pay. They have a very long list of obligations as a client that they need to fulfill. We'll walk you through some just high level. They need to provide the planning activities in this scope. A planning, it's not only supplier analyst, it's a very huge turnkey that the customer is not involved. But like in 80% of the contracts, customer needs to give things, at least needs to give approval or needs to give time to kick off the project, to set the the commencement date, they need to give access. They need to give, some permits to start the project. As I said, they need to approve and comment the drawings on time. So of course, if we submit something and they don't approve it on time, so it's in critical path, we'll have a slippage in the planning. So to be sure that this client knows their obligations. When we have a project under LC, letter of credit, it's not the supplier who open it, it's the client. So they need to be we need to be sure. Of course, we need to agree on the draft, but at least they need to issue this draft on time and then open it, of course, on time and keep it opened and amended on time. Complete the shipment documents. It depends on the Incoterm. If the client has if the contract has Ex Works or FCA, then the customer needs to complete some shipment document like a bill of lading and need also to hire the forwarder. Provide and request the access. So I said like that they need to give us the access, a safe and healthy work environment, security. Provided tools, sometimes they have to give some utilities, some tools, some equipment, so they need to give them on time as per the planning. Obtain the necessary work permit, this is what I said before. Validate the work progress. Sometimes, a validation of the work progress, it's on a critical path, so to go in the right direction, to issue the payments, so they need to do it on time, and they just, they don't need just to ignore it. It's an obligation for the client under the contract. Issue the CVO. If there is any modification to the contract, they need to sign the CVO on time and give us the right payment for that. So if not, it will delay the work, of course. Provide the requirements. If any performance, sometimes we have some tests and they need to give us some tools, some lab tests. So to be sure if we succeeded the test or not. So they need to give this on time for progress of the project. Pay the contractual CVOs. This is what we said. Sign any, can be taken over certificate as per the contract. It can be a progress. It can be installation completion. It can be anything that you need to sign on time, of course, because we can have a payment linked to it. A progress can link to it. A project continuity can be linked to it. And release the bank warranties as per the contract. Sometimes we give them a bank warranty valid for like, I don't know, until the delivery, and they don't release it. So I keep turning, it means we keep paying. So as per their obligation, if we fulfill, if the other party fulfill their obligations, so as a client, they need to release this and to need to fulfill their obligations as well. And then sign off and close the agreement. Sometimes we finish the contract and then they don't sign off, they don't release anything. So it means it's an obligation. They need to release it because there are payments, there are other actions following. So they need they need to respect this as well. From the other side, seller. So also as a seller, you have obligations such provide the planning, because a planning, it's not by one party, it's a common, I can tell, obligations. So both parties, they need to keep their milestones updated. Each party, if they have any slippage, they need to keep each other informed. Issue comments and drawings. Of course, we need to issue drawings if there is any comments come in, so we need to respond to them on time. Bank warranties is our own our obligation as a seller, so it needs to be issued on time. If we don't issue it on time, we cannot blame the customer for any payment related to it. Complete the shipment document. For example, if as a seller we have an Incoterm DAP, it means we need to complete all the documentation on time. So we cannot blame anyone for any delay. We can be blamed. Perform the milestones as per the contractual target. So if we need to follow the planning, and as I said, if there is any delay, do the recovery plan. Provide qualified manpower and project team. As a supplier, we are considered an expert, so we need to give the right manpower, the right persons to perform the project. issue the progress reports, if any. In some contracts, we have the obligation to issue the progress report, and as an advice for me, a progress report is key on the project, so it can keep both parties informed, and it's very good practice, I can tell. Respect the contractual specifications. If there are some technical specifications that we agreed on, we need to respect them. If we see that we cannot at any stage of the contract, we need to negotiate and request for a deviation. If there is any modification, we need to ask for a CVO to be sure that it's aligned with the whole contract. If it's gonna affect the payment, gonna affect the plan, gonna affect anything, we need to report it. This CVO can be coming from both parties, so it needs at the end to reflect all the changes that are gonna come to the contract. Issue the TOC. Usually, as a supplier, you issue it, but the other party counter-sign it and approve it. Issue the contractual CVO. As I said, usually if it's change coming from the supplier, you issue this CVO, and the amendment usually comes from the client. Clear the snag on time. So at the late stage of the contract, when we finish everything, we never block a big project for some snags. So there will always be some snags to finish, some little things that they will not block the whole project and the whole production. So we need to clear them on time. We don't need to ignore them. This is related to the priorities. So it can not be like the biggest priority of the project, but it's a very important task to be cleared as soon as possible. So to not, sometimes there are some payments related to it, and also some manpower, keep it on site, it means money. So we need to give it the right priority. And then provide contractual documentation. Also, it should be included in the management of the priorities, because this is the last task, but sometimes we have some payments related to it. The project, everything is ready to be closed, but just one document will keep the project open in the books for like years, so it needs to be cleared. Before concluding, I will here give you some examples. So the first example there, choose related to the contract signature. So a seller wins a contract for supply, installation, and commissioning of a factory with a client. The contract price is 3 million. So the proposal provides a commencement date 1st of November. And then the time schedule provides a commencement date 1st of December. And then due to the extended negotiation, like due to some holidays season, the contract have been signed on 10th of November. And the down payment was not received until the 1st of February. So in this case, when does the contract actually start? What should the seller LTD do about the discrepancies? How can we avoid this discrepancy? Just give you 10 seconds to think about it, and then I will show you the answers. And you can see after that if your answers were aligned about what the answers are here. Okay. So for me, the answer to the first question is when the contract actually starts. The risk, it could be start by the 1st of November, because in our proposal we said this is the starting date. But what can we do, or as a seller can we do about the date discrepancies? So usually we need to ensure that the commencement date is properly defined. So if you have in the contract the date is the down payment, it means in this case there will be no discrepancy. If the date is the proposal, then it's the proposal. And they need to check the planning. Even sometimes depends on the contract, where is the date properly defined. So the planning, if it's set a different date, and then in this case, at the kickoff, after the signature, we need to update the planning. And then all the parties will be aligned about where is the commencement date. And how can we avoid this discrepancy? So clarify the right and obligation in their contract to all parties. When the contract is signed, the kickoff, do all the clarifications. If there is any discrepancy, issue a CVO and issue an amendment. And then all the parties will be aligned and our contract commencement date will be defined. And then the planning will be applicable without any discrepancy. The dates will be clear. Second example. So during the manufacturing and the delivery phase, so a seller wins a contract for delivery of 5 months after the down payment for a contract price per million. To honor this date, seller requests the client to approve or comment the drawing 2 weeks after their issuance. Under the contract, seller will be liable in case of late delivery as the only milestone subject to LDs. So the LDs, the only milestone subject to LDs is the delivery, okay? And then client has delayed the drawing approval and come up with delayed comment that might generate scope modification. The extra engineering hours have been borne by the seller. So without informing the client, we proceed and we did the modifications. We were delayed in the engineering phase. No problem, because the engineer is not penalized, so nobody said nothing to not offend the customer. But then the delivery have been delayed. So the client is not satisfied and holding a partial payment on the delivery payment term as LDs. What could be done to avoid such situation? What are the claims that seller could get instead of paying LDs or the additional working day fees with no additional compensation? I'm going to give you another 10 seconds to have your answers in mind and see if they are aligned with mine. Okay. What could be done to avoid this situation? For me, is notify the delay of the drawing approval. Notifying a delay will not offend the customer, but at least will be clear that there are some delays. It might, delay the delivery. It doesn't mean that automatically we'll deliver the LDs. Of course, if we can mitigate some delays or do an acceleration plan to show the customer, they will be happy to listen to it. At least we'll show them that we are on control. Mention the impact to the planning to the client and send notification to client for extension of time. If this delay is not generating dollars, okay, we can make a gesture to our customer if it's a good customer to us, and if it's, it didn't generate money for us, then it's fine. But at least an extension of time should be set. And what are the claims that the seller could get instead of paying the LDs? Because this was a very good opportunity, but it turns to a risk because we didn't communicate well about it, we didn't well manage it. So we could claim extra engineering hours. We could claim the fees related to the payment term paid postponement. We could claim extension of time and project team fees. And we could claim the payment term as per the initial planning to improve the seller cash flow. But all these claims and opportunities turns into risk and turns that the seller will be under the client's mercy, and it will not be, showing that they are doing, some free of charge work as a gesture, but they will be, in a weak situation and asking for mercy. Third and last example about defect. So once again, an example, seller wins a contract for the supply, installation, and commissioning for a factory, and the contract price 3 million. 1st August, a visit to its vendor facility. Seller discovered there are some defects on a compressor, for example, and the defect appears to be serious. So the seller has concerns that this defect may mean that we would not meet the contractual date subject to LDs. So what should the seller do about this defect? It appears that the vendor's defect will impact the schedule by 4 weeks. How should the seller address this vendor delay? Should the seller tell the client about the defect discovery on the vendor works? Once again, 10 seconds, sorry. And then I will show you the answer, and you can, after that, tell me if you are aligned with mine. Okay, so what should the seller do about the defect? Issue supplier's defect notice, follow-up action plan requested in the notice, and keep on track of the cost impact defects with the vendor. So we can deduct this from the monies from them. And then claim LDs if relevant to the supplier. Because with the vendor, we have always a contract. It might not be, bigger as our project, but at least it can, give us some reports. And about the second part of the question, my answer is to be transparent with the client. We shall not hide this. So we shall inform them about the delay, explain the action plan, work together on a mitigation plan, and of course assist with the legal about our total exposure. If we agree on the client with the acceleration plan, so this acceleration cost shall not be in addition to our LDs. So we need to be sure with the legal that we are covered from this aspect. If not, take it with the customer and be sure that it's clear, so we'll not be double penalized. But one thing is sure, is to be transparent. As a conclusion, for me, if I can conclude in one word, is clear communication. And then good records and continued follow-up are invaluable. We need to be clear in communication. We need to keep records, to keep following up, not disappear. Show the customer that we are here. Show the customer that we have control. If there is anything, they can trust us. So after that, tomorrow we'll have some tips in this regard. So we can discuss about this very, very, this priceless aspect of communication. So today we have been walking through the contract management phases and who is doing what, how and where the contract manager is acting during the contract life cycle. And we have, work very generally and some rights and obligation of the parties. Tomorrow, we will go more in detail on the contract manager role in the tendering phase, some key clauses, and some negotiation. Sorry, there is a mistake. Some negotiation tips. I hope that you enjoyed this session. Thank you for your attention. And if there is any question, I'm here to answer.
Yeah, hi. I'm finding few questions in the comment section. So, okay, so a few questions Pravina has answered. Thank you for that. So there is one question from Rajat. To what extent we should be strict on timelines, as these are essential to both the parties?
Sorry, can you repeat before essential? Where is it? Us?
To what extent we should be strict on the timelines, as these are essential to both the parties?
For me, we should stick to the contractual planning. If there is any change, it should be, well understood. It should be, both parties will be aligned to it. Time costs money. So if there is slippage on the other part and it's not reported, for example, slippage in the planning from the supplier, not reported to the customer, it will cost money, LDs. If the opposite is the same, so the client having some delays, it will not be reported to the seller. It will have some additional cost. So in normal practical I can say, practical life, the schedule, I mean, to not be pessimistic, it's very, very exception that we stick to the schedule at its time, minute, and day. So there will always be some slippage, but to be on control of it, and if there is any change, to be well managed, and to become the main base to be stick on. That, I don't know if my answer is clear, but I mean, we
Yeah,
should,
I
the
hope Rajat,
beginning
your question is
is the
answered.
manual. Hmm.
Yeah. Okay, so any more questions? Before someone pops in, I have a question.
Yes.
So you told about like the drafting part and research and other things. So my question is, the law is different across the states. Forget states, like it's like even states, countries, continents, it's all different. So when we are entering into contracts between two countries, how do you, like, what is the tip that you would give us in researching? Either it is reviewing or something like that. For example, now recently I had a situation wherein I had to research on the anti-slavery laws that were in Switzerland for reviewing one of the professional services agreement. So it was really a very hard time for me because I had no idea about anti-slavery laws that are existing in Switzerland. So I took a lot of time in that. So what is your tip on that, and how can we push ourselves in that area?
For me, my answer will be, I mean, big companies, they have their own contract templates, contract CNCs,
Mm.
but it's became, I mean, a public information that we have some, I can tell, 10 TNCs that answers the market standard. We have FIDIC, we have NIC, we have PMBOK in North America. So these are, I mean, those public or those standard TNCs are online with the market practices
Mm.
and with international market practices. Of course, that they can be amended to adapt to the situation, but one thing is sure, that they are not in contradiction with the regulations like Switzerland, like UK, like European, like American, like Indian, like wherever. They can be silent about some things. They can be to be completed about some clauses. For example, the force majeure, that it's silent in the UK law, latent defect, that they are silent in some jurisdictions. So things like that. But I mean, for me, the base to start with is the market standards.
Okay. Yeah. So any more questions? Yeah, okay. There are no more questions. Okay,
Okay.
so thank you very much. Yeah, it was really insightful. It was like the presentations were literally outstanding. Especially, I put specifically, I have to tell the slides wherein you had mentioned about, I think it was fourth or fifth slide, wherein you had put up various roles like finance, this thing, that thing. It was like the view of the site, you understand everything. It was really good, and we are very much looking forward for tomorrow's session. And yeah, thank you so much. We'll meet tomorrow at the same time.
Thank you so much. I will speak to you tomorrow. Have a good
Yeah,
day. Thank
thank
you.
you. Thank you so much.